All right. Hello, everybody. Good to see you all. I'm glad for those of you who are able to join us today live. I've got a handful of questions that I received from landlords who either sent questions through YouTube or sent questions through our Facebook group, whatever it is. In whatever way you're reaching us, we want to make sure that we're reaching out to you with answers to those questions. And so, like I said, I've got 7 of them here. If you've got a question during the stream, I'm happy to answer those questions for you as we go along. But today's topic is all about the unintended landlord and how that comes about happening. And so, again, as we'll wait a little bit for a few more people to join. But I do want to get started with the topic pretty quickly here. And I want to announce that starting in January, we're going to move. We used to do the live stream on Fridays at 11 a.m. We're going to test it out to see what it's like going at 4 p.m. Houston time on Wednesdays. If you like that, give us a thumbs up. If you have a suggestion for us about a better time slot or something that might work better for you, please don't hesitate to let us know. I'm definitely happy to get your input on what works best for all of you. But when it comes to the unintended landlord, we want to talk about situations where you might be subject to landlord-tenant law or subject to the requirements of landlord-tenant law, even though you never expected to be. So one of those, and my long form video that I released yesterday is all about evicting a long-term guest. And so sometimes you become a landlord because you allow someone onto your property for an extended period of time. And now you have to follow what, landlord-tenant law says in your jurisdiction for removing them if they just won't leave voluntarily. And unfortunately, that sometimes happens. And so if you're having to utilize landlord-tenant law, you want to make sure that you have some sort of protection. And one way is to get educated. And so channels like this, or like our Facebook group. If you're in Texas, we have a Facebook group called Texas Landlords. These groups help people who are just starting out in the landlord business, including people who never again intended to be landlords. And so just because someone's sleeping on your couch and they've been there for a long time doesn't mean you might not have to follow the law. And the question is, how do you get access to this information quickly? Again, you can go to school like I did, or you can check out this YouTube page or join a group of seasoned landlords who can help you out. But the long-term guest is only one of a number of scenarios where you'll have this unintended landlord. Another is when someone passes away. And this is a very common situation. Mom and dad pass away and they leave their house to you, and suddenly you've got a property that you're not real sure how to use, so you decide you're going to market it as a rental property. But the truth is, because you weren't prepared for this, you may not make all the best decisions. For example, one very common error that happens in these situations is that landlords just get any old lease they find online, and that is a big no-no. If right now you're operating with something you just Googled and you have no idea whether or not that lease actually is appropriate for the state where you lease property in, that could be a big problem for you down the line. Additionally, sometimes you get these very bare bones leases. If you go to an office supply store and get just a generic residential lease, it's not likely going to be tailored to Texas law, and it's not likely going to be, or wherever it is that you're leasing property. I practice in Texas, but it's not likely going to have all the firepower you could otherwise have if you had a lease that was made specific for your state and then specific for your needs. And this is one of the services that we offer, is we'll tailor your lease to suit you, not just state law, not just for your local jurisdiction, but for you individually. And if you have multiple properties, you might want to tailor that lease to suit each individual need for each individual property. All of this can be done with good planning and great drafting. But sometimes when you become an unintentional landlord, you're given a property and you're quickly putting it on the market. You're going to make these quick decisions that end up costing you a lot of money or big headaches when you're trying to enforce something that your lease just doesn't have, or you wish you had something in there that definitely is not. And so you want to be ready, and if you are taken by surprise, you want to know where you can go. Certainly, you can go to a real estate group. There's tons of them, especially if you live in the more densely populated areas of the country. Lots of real estate groups online. These groups meet in person. And of course, you can always seek out a landlord-tenant attorney. Anywhere in Texas, I'm right here. Hello. Ernie Garcia, landlord attorney, with tons of content on this channel for you if you happen to find yourself unintentionally leasing property because you've inherited it after someone has passed away. And the final situation where this comes up is when you have to move quickly. And this is a common scenario when someone gets a job in another town or in another state, but they want to keep the property that they've got. Maybe they've paid it off or they're nearly paid off, and they want to lease out this property and upgrade because they're going to another town, or they just decided, you know what, I want something bigger or I want something smaller and I'm close by, but I don't want to get rid of this house. I've nearly paid it off. If that's the case for you, you might find yourself in a situation where you think, I've never been a landlord before. I've never thought about landlording in the past, but I would like to put this house on the market and make a little cash. Well, one of the things that people don't consider in these situations is the change in your insurance needs. And this is quite common. I talk to a lot of landlords, particularly landlords who are using a method where they buy property, stay there for a short amount of time, secure that property with maybe an FHA loan where the interest rates are better, and then they move, buy another property, and do the same thing. Well, the problem with this setup that many landlords don't, especially new ones who don't do this a whole lot, what they don't see is that the insurance needs change when you're using your property as a rental. And so you might have insurance while you're living there that protects your structure, protects the home from fire, flood, wind, all of these things. But once you move, that policy may no longer be sufficient. In fact, it may not pay out if fire, flood, or wind damage the property because you're no longer using it as your exclusive residence. You're going to want to make sure that whatever you're doing, wherever you're living, if you're using some property as rental property, that you actually have proper insurance for it. I talk to a lot of landlords who own one or two properties who have transferred this way. Again, maybe they've moved to another town or another state or just down the street and wanted to change where they were living, but keep their prior home, but they don't change their insurance. It's always a good idea to make sure you've got proper insurance for your rental property. And this is true whether you've got one house, whether you got it unintentionally, intentionally, whether you bought it for the specific purpose of leasing it out, or not. Again, you've got one, you've got 10, you've got 100. You want to make sure that you are always properly insured. But one of the common things that unintentional or unintended landlords get wrong, unfortunately, is the wrong insurance. Again, if you're going to lease property, make sure you're set up to protect your property with proper insurance. So now we're going to go ahead and get to the questions that we have. Again, if you've got a question, I want to answer it. Make sure that you leave it for me in the chat. I'll be looking for it as we proceed. But I will be thirsty from time to time. All right. Let's get rid of that. Okay. Question number one. Got 3 tenants and one wants to terminate due to uncomfortable living conditions. The other 2 want to remain and do not wish to let the third one out of the lease. Rent is paid, it's up to date, but the disgruntled tenant claims there is an unauthorized occupant. The other 2 deny it. Can the disgruntled tenant terminate the lease with prior notice if the other 2 wish to remain in the current lease? Short answer is no. So you've got three tenants, all of whom signed the lease. All of them have the same rights, but also the same obligations under the lease. Can any one of them, on behalf of all of them, terminate the lease? And the answer is no. Just because you have one disgruntled tenant doesn't mean that they can make decisions that absolutely affect the other, except of course when it comes to breach. Their breach would negatively impact the other two, but they cannot unilaterally terminate without, again, some valid basis. The fact that they're simply unhappy or the fact that they're simply ready to move on is not enough. And so no, one tenant by themselves cannot unilaterally simply walk away without consequences going to all of them. Generally speaking, all three tenants are going to be jointly and severally liable for each other. So that if one walks away, and that means that only 2/3 of the rent is now being paid, guess what? All three of them are culpable for the unpaid rent amounts. So no, that disgruntled tenant can't do it, even if he suspects that the other two tenants are in breach, because the truth is that breach runs to you, not between them. And so they might have their own agreements to do or not to do certain things, but that doesn't necessarily change the agreement that all three of them collectively have with you, the landlord. Okay, next question. Here's an accidental landlord. I did buy a lease package from you to start. Great, thanks. One question I have is, do I need to set up a separate bank account for the rental? I have the lease from you. I have the house in a trust now, but what else do I need to legally protect myself? How do I file taxes for example, or what direction to go for with that? Okay, well, let's address the tax issue first. Number one, I'm not a tax attorney, nor am I a CPA, and I don't offer tax advice. That's something that I would strongly recommend that you talk to your tax professional with, because I don't give tax advice. But in terms of liability protection, I spoke about it earlier in the video. Insurance is huge. You're going to want to get the appropriate insurance to cover your rental property as you seek out tenants to live on that rental property. In terms of the trust, it should shield you from individual liability, assuming that the trust was set up properly. That shouldn't be a problem. You should be able to continue with the protection of the trust and be shielded from any individual liability. Now, one way to erase that individual liability is to have an improperly signed lease. And what I mean by that is, if your lease is signed in the name of your trust, but for some reason you also add your name in there personally as the landlord or personally as the property manager, that's just not something that I would encourage, because you defeat the purpose. You regain personal liability by including yourself in there and your individual liability. And so if you're asking, well, how would I possibly sign the lease if not with my name? Absolutely, you'll likely have to sign it with your name, but not in your individual capacity. And it's important that you limit your representation as to that of an agent. And so let's say your trust is the 123 Happy Guy Trust. And so you're signing as the agent for 123 Happy Guy Trust. And so by making it clear that you're signing as the agent, you continue to have that shield of liability between you as a personal individual and your trust as an entity, the owner of the property. So definitely you want to have an entity set up, whether that's an LLC or a corporation or a trust. Definitely you want to have a good lease that's well drafted, where you are not giving yourself back personal liability. And then finally, you want to be able to insure the property to the fullest extent with a proper insurance policy. Now, the last question had to do with the bank account. And yes, this is another thing that a lot of new landlords get wrong, particularly when they're trying to preserve individual whether they're trying to secure themselves from individual liability. The moment you commingle your personal funds with funds that belong to the trust, is there really a difference? Is there really a shield? Is there really a distinction? So if the trust has its own account and the trust manages its own account independently, and then perhaps you are the beneficiary of that trust and the trust sends payment to you, that's a completely different story than if you and the trust share the same account. That's how you mix or commingle is the legal term, where you commingle your funds and you kind of destroy that shield between you and the trust as an individual and then it as its separate entity. So yes, get a separate bank account, shield yourself from individual liability in that way. Okay, question number 3. The law office of Ernie Garcia. If I live out of state, I live out of state, sending a 3-day notice to cure or quit, certified mail, good enough in the court's eye, or do I need to have someone post inside the door as well? It's a fair question, but if you are suing someone in the state of Texas, the state of Texas only requires really even just regular mail. The problem with just sending it through regular mail is without some kind of tracking, it's hard to prove. And so I always recommend send it by regular and certified mail. That's the best way. No, the court's not going to require, in Texas, the court's not going to require you to also personally deliver it to someone on the premises. The mail is the extent or as far as the courts in Texas will go. Now, in your jurisdiction, if you're outside of the state of Texas, I can't speak for you and what would be proper in terms of proper delivery. Perhaps your jurisdiction requires mail and personal delivery, but that's certainly not the case in the state of Texas. So number 4. I'm negotiating for a woman who has a federal lien on her land from an SBA loan she couldn't pay back after her husband died. Now she wants to sell her property. How hard will this be for her to sell the property and get cleared from this lien from the Department of the Treasury? She's getting her Social Security and naval pension garnished because of it. Well, that sounds like a really messy set of facts. And it sounds like there's a few details that, are not in front of us. So it's hard to really answer this question without knowing a little bit more, but I'm gonna give it a shot. So let's say that the property has a value of $400,000. So long as the lien is significantly less than that and can be paid off in full by the purchase price that the seller would receive, there's no issue. The only time you might have an issue is if the lien is greater than the value of the property. Because if you sell for X and X is less than the value of the lien, you're going to be stuck with a balance. And so you won't be able to take the house free and clear. Even if the full payment amount goes toward the lien holder, you're still going to have a continuing debt owed on that lien, and the lien won't be released. But assuming, again, a $400,000 property, and let's assume that the lien is $250,000, and that's all the liens that are included. Well, certainly at closing, especially if you go to a title company, at closing, the title company is going to take from the $400,000, $250,000 and clear out all the liens, thus granting you releases so that you can take that property free and clear, and then $150,000 of it goes to the seller, whoever that happens to be. In this case, it's the widow, and so she'll get a payday, all the liens will be released, and you, the buyer, should be able to take the house free and clear, and then she won't have stuff being garnished out of her accounts anymore. That does sound pretty rough on her at the moment. Again, if those liens, however, exceed the value, number one, it's going to be impossible for you to secure a loan for that purchase. So unless you're paying it cash and you're willing to assume the additional liens that will remain on the property, I don't know if this is a good deal for you. But assuming that the purchase price exceeds the values of the liens and that all the liens will be paid off at closing, that's the way it works. And you should be able to take your property free and clear if that is the case. Number 5, what is the best or top option for deeding real property to your children while maintaining minimum tax liabilities? I understand it's more of a tax question, but what has been your experience? I'm glad that you asked this because actually over the next few weeks, we're going to be getting into estate planning conversations here. And I look forward to sharing these estate planning topics with you because they come up so often. And so if you're saying, look, I've got 4 properties, I've got 4 kids, and does it make sense for me to deed those properties to my children right now? Does it make sense for me to write a will? Does it make sense for me to operate a trust? Or is there some other option? Because unfortunately, what happens a whole lot is that people who own property simply don't make that decision during their lifetime. And once they're dead, their kids are scrambling, sometimes years later. I see clients who come in and say, Mom and Dad died more than 10 years ago, and the deed is still in Mom and Dad's name. There are no liens, we pay the taxes, but now that we want to sell, we can't because title is still in Mom and Dad's names. And so there are hoops that we can jump through to transfer those titles even after death. But there are much cleaner ways for property owners to transfer ownership and title and control over to their children, depending on how they want this done. So let's talk about first, the classic is the will. So in the will, an individual can leave personal property and real property to whoever they want. Anyone on the planet can get it. And so let's say that an individual has 4 children and 4 homes and says, I want to leave home A to the first child, home B to the second, and so on. Every child gets a house. Well, the one issue with this is that the will need to be probated. Before that transfer occurs, someone has to take the will to the court, prove it up, and then transfer out of the estate of the deceased into the names of each of the individual owners. And it's not a ton of work, but it is some work, and it can be a bit of a hassle, especially depending on how the family is set up and who will ultimately, move for probate and enter the enter the will, and then make these transfers. It can be a bit of a headache, and there are easier ways to do it. But in terms of taxes, this would be the best way to do it, because if you do it while you're alive and just transfer deeds to all 4 kids, once your kids sell the property, they're going to sell it based on, and I don't want to bog you down with a capital gains talk, but there will be a much more significant capital gain discussion when they sell the property if you simply deed it over to them, right, than if they get it through your will or through some other means. But if they get it through your will, they take it at the present value, and when they sell it, their capital gains are significantly less. So that's one of the really big benefits of transferring property through your will, is the tax benefit that your heirs will experience because of that area of the law. But again, they have to go through this process, and somebody's going to have to do the heavy lifting and do this transfer. The other possibility is by way of what's called a transfer on death deed. And this is sometimes really appropriate for someone who just owns the one house. And so Mom owns one house, she has 1 child, and she's going to transfer the deed to that child upon her death, but she doesn't want to go through, because she doesn't have anything else, still want to go through probate and a will and all of these things. So there might be a reason to draft up a will anyway, but there might not be a reason to need to probate, especially if the real property, this one house, can be transferred with a transfer on death deed. And here's how it works. Mom signs the deed over to child A. And that transfer on death deed is filed, but it's not effective until mom passes away. And in fact, if something happens where either mom and child have a falling out, or the child predeceases mom, mom can rescind that, change it, and then transfer it to somebody else. So mom still has quite a bit of control over her own transfer on death deed. However, assuming that mom signs the deed and there's no falling out, there's no change in mom's plans, upon mom's death, the beneficiary of that deed simply has to file an affidavit, and I'm talking procedure in the state of Texas. This is very common throughout the U.S. File an affidavit with the county clerk's office, wherever deeds and titles and liens are recorded in your county. File that affidavit with the death facts of the parent, and boom, the beneficiary is, by a simple filing, now the title holder of that property. So a transfer on death deed is a similar transfer. They will take the stepped up basis and therefore reduce their tax liability when the beneficiary ends up selling the property in the future. It's a very clean and very easy way to transfer, especially if you have just one property and only one beneficiary. Transfer on death deed, if that's an option that works for you, that's another one that we suggest. So we can do a will for you and set that up for you. We can set up transfers on death deeds for you. Additionally, you can set up a trust. And the trust works a little differently. And what the trust could do is take all four properties. We go back to the original scenario where an individual has four properties and four children. And what they do is they say, look, I'm transferring all these to the trust. And so the the trustee will have control over these properties, but I want for me to be the beneficiary until I die, and upon my death, I want my children to benefit from these rental properties in equal shares. And so the trustee can manage the properties, sell them, lease them, take care of them in such a way that the benefit goes to these beneficiaries, and the trust document controls how all that is handled. So if you've got four kids, but you don't really trust that third one, he can still or she can still receive the benefit of the property without full control of it. And so this is another way that you can transfer property to your children, or at least the benefits of the property, without the threat of some one of the questionable children kind of squandering the inheritance. So whether you want to leave things outright to them either through a will or through a transfer on death deed, or you want something slightly different and setting up a trust, these are all things that an attorney can set up for you. And if you have questions about it, don't hesitate to ask questions. These are very important topics as we talk about end of life sorts of questions. But yes, the trust would also limit tax liability on the beneficiaries. Again, each of these has kind of different nuances to them. Don't just rush into one. If you're unclear, sit down with a professional and talk to them about it first. Okay, question 6. If a tenant does not fulfill their lease term, vacates in the middle of the lease, is there much a landlord can do to recover? It needs to be easier for landlords to recover these lost expenses and report on tenants' credit. So there's a couple of things. So number one, you always want to make sure that you have a full security deposit that's at least 1 month worth of rent, because hopefully if someone just skips out in the middle of the night, you can find a replacement for them in 30 days. If that's the case, then you're going to minimize your losses. You may still have some, but that security deposit is your easiest way to protect you from such an event. The other would be going after them with a civil lawsuit. And so, I talk to landlords about this all the time and whether it makes sense to go after someone in a civil lawsuit. And sometimes it does and sometimes it doesn't. I always ask two very simple things. Number one, can you locate them? Because if you can't find someone, you can't sue them. And number two, if you can find them, do they have the capacity to pay? Because if they don't got cash, the judgment itself is not very valuable. It's a nice piece of paper, but it doesn't get you much. So can you find them and do they have the capacity to pay? Now, I know for sure in the state of Texas, even if you want a judgment for $10,000 or $15,000 or $20,000, if the judgment debtor or the defendant doesn't have the amount of money available to pay, doesn't own property, doesn't have accounts that you could potentially seize, you can't garnish their wages in the state of Texas. In other states, you potentially can. And so that would be another capacity question. Are they gainfully employed? And if you can garnish their wages, is that an available option for you in your state? Again, in Texas, you just can't. So if it doesn't make any sense to go after them because you can't find them or they don't have enough money or they're not gainfully employed, then I would just say, again, protect yourself by getting rid of bad tenants faster. I always preach evict faster. And then always, make sure that you haven't done anything to minimize or limit your security deposit, and certainly never, ever, ever take a tenancy without at least 1 month of security deposit because stuff goes wrong. And if it doesn't go wrong, great. People love getting their security deposit back, but 9 times out of 10, you're going to need some of that deposit to cover some of your losses. So I've got one last question I want to check real quick to see if anything else has popped up. Okay, I've got another one that just popped up beyond this one. So I have an unmarried couple who signed a lease January 30th, 2024. Less than a month later, the woman left as they broke up. I offered to rewrite the lease. He declined. I am renewing the lease for him. He wants her name off the lease. She still visits there. They've got a son together. He's a single father. Do I need to inform her in writing that I'm renewing the lease without her name on it? You can't renew the lease if the original members of the original lease don't sign off on it. You just can't do it. So if you're asking, well, does that mean the lease goes on forever? No, in fact, you should terminate the original lease and then just sign a brand new lease with the gentleman who's still there. As long as he qualifies, as long as he makes enough money, as long as he is still credit worthy enough to handle the full value of the rent, just terminate the first lease and sign a brand new lease with those terms with him as the only occupant. Now, if you terminate the first lease, you technically have to issue back within 30 days the security deposit to both of them. That being said, make sure you take a new full deposit from him for signing the second lease. Now, this can sometimes get complicated because they don't speak well together or they don't have a joint checking account together anymore. Well, guess what? That's not your problem, but you do have to follow the lease. Now, he may say, no, keep my half and apply to the next one and just send her half of the deposit. Well, the reason that doesn't work is because you have no idea who actually paid it. And if they have separate accounts and it turns out she paid the full deposit amount, she may be expecting the full deposit refund. That's bad news for you. Again, you don't know how they paid this deposit. All you know is that a deposit was paid by both of them. Return the deposit funds in both of their names and let them figure it out. Then for the new lease, take a new deposit from the remaining party and then proceed without the wife. That's really the only way you can legally do it. You cannot renew a document if the original party to the original lease is not there to sign off on that renewal. Now, If she were there and she signs off on the modification that she is no longer part of the lease, that's a different story, but he would have to agree to that. So yes, all three of you together can modify the original lease to exclude the wife, and then yes, from that point you can renew. But unless she's willing to sign or unless she's part of it in some way, your best bet is to terminate, send back the deposit, start a new lease, get a new deposit, and then proceed. Okay, so that is that last question. Let me take a look at this question here. Okay, first question up here. How you doing? Shawmek. What are the must-have documents every landlord should have other than the lease? Templates like notice of lease violation or notice of non-payment, etc. Oh, wow. So, I tend to believe that there's a lot of stuff that landlords should have other than just a lease. Yes, you want to be ready to issue notices of default, notices of non-renewal, or a notice of termination, and a notice to vacate. So there are multiple notices that you might need, but the one you're going to use the most often is the notice of default. So something gets wrong, something gets done wrong, maybe rent's paid 5 days late, or maybe they leave the trash cans out too long, or maybe they haven't cut the grass in 2 weeks. Notice. You always want to issue a written notice. An oral notice doesn't count. So you always want to issue a written notice. But other documents that you're going to need alongside your lease, you always want a good set of house rules. And so among your addendum, you might have a pet agreement. You might have some kind of mold or a bed bug disclosure. I've seen those. You might have a lead paint disclosure if your house is older, if it was built on before 1978. And in Texas, we're required to have a floodplain disclosure. And so you're going to want a bunch of necessary disclosures per your jurisdiction. But definitely one that gets left out, even when people meet all of those requirements, they leave out their house rules. And so the house rules are extremely important depending on, the needs of your particular house. You may have, for example, a swimming pool. And there may be some specific things you don't want going into the pool, or some specific acts you don't want carried out around the pool. You may have a water softener that needs regular maintenance and upkeep. You may have, security cameras set up on the perimeter of your home that should not be in any way touched. You may have all sorts of things individual to your property, or you may have multiple properties with different needs that you want to address in your house rules. You may want to reiterate certain things that are of special interest in your neighborhood. For example, noise issues or parking issues that come up that, again, are just not routine for most leases, but might be particular to your lease. So I always, stress to landlords, have house rules out there. One very common thing that comes up a lot is, well, what can I charge as a fee if I got to go and take care of some kind of maintenance or take care of something that the tenant was supposed to do that they're just not getting done? How can I possibly charge them a reasonable fee? Do I just make it up? Where do we get what is a reasonable fee? It's in your house rules. And if you've already set a reasonable amount and they signed off on it and agreed as part of the lease, then boom, you're done. So if you got to work a couple of hours in there cleaning up some mess they made or mowing the lawn or doing something, and you say, look, I can charge you $40 an hour because you agreed that's the case, there you go. And it makes it much easier for you to carry out these things if it's in the house rules. And so your tenant's not going to know precisely how to take care of your house unless you tell them. And your house rules would be an excellent way for you to tell them about the particulars of how to take care of your house. Okay, and what looks like the last one. Rafat Hasnet says, if I want to issue notices of default or notice to vacate by certified mail and say, please cure the default within 3 days, how do I write the letter not knowing when the letter will be delivered? That's an excellent question. And it's something that comes up a lot is, how can I enforce something with a deadline if I don't know when it's delivered? Well, definitely when you send something by certified mail, Shamek, you're very welcome. And definitely when you send something by certified mail, you have tracking, but unless you send it by regular and certified mail, that certified letter may never get there because they may just get a little note in their mailbox, and they may never go to the post office to collect it. So I always suggest sending important notices by regular and certified mail. But here's another trick. What does your lease say about your ability to notify your tenants? If the notice provision in your lease is blank, there's almost nothing more frustrating than that when I see it, and I see it a lot in a lot of leases. I always recommend to landlords to fill up the notice provision. Give them a valid way to get a hold of you, but also get multiple mechanisms for getting a hold of them. They probably have a work email and a personal email. If they're a couple, husband and wife, have a work email, personal email. If you want to communicate via text, make sure that your lease explicitly allows notices to be delivered via text. Maybe you have a tenant portal because you use one of these property management software or property management programs, some kind of online setup where they can communicate notice through the tenant portal. So if you've got 5 or 6 or 7 avenues for communicating notice to your tenant, that's always the best way for you to know that they got it, when they got it, and that they were in fact informed of these defaults. And so certainly you can track things with the US mail, but email and text are usually much more immediate ways of getting notice to someone, especially if you want to give them a short time frame. Now, let's say you've already done this and you can't do the email, you can't do the text, and you've already done it. Well, then the rule of thumb is to wait a reasonable amount of time. Generally speaking, if mail takes 3 to 4 days to get there and you don't have a way to track it, you can presume that 3 to 4 days is what it took to get there. If the notice says you have 3 days to cure, then about a week, you can give them a call and say, hey, I sent you a notice. Did you receive it? Have you taken care of X, Y, or Z? They say, yeah, I got it. I'll get around to it. Then maybe you give another day or two once they've confirmed that they received it. And if they haven't taken care of it, I would issue a new notice, probably with a way that you can track better. But that's essentially the way we handle when it's unclear whether you've given enough time. As long as if you give way more than what you say in the notice, a court's going to agree that you gave a sufficient amount of time for them to do it. If you can track it, it's even clearer. And again, the way you do that, get multiple mechanisms for contacting your tenants. So for those of you who stuck around, I really appreciate it. And I appreciate all of you who submitted questions, either here or through Facebook. This is something that I want to do regularly every Wednesday at 4 o'clock Houston, which is Central Time. I'm here. I want to be an asset to all of you. Of course, if you missed it, there'll be a replay. But I want to be here every single week and give you the opportunity to ask me questions, and I'll do my best to get an answer to you as quickly as possible. You're very welcome. I'm glad you got to ask your question. Hey, for all of you, I hope you have a great rest of your week. I look forward to seeing you next week. And let's see, next week's topic, for those of you who are still around, I'll give it to you now. Next week's topic will be on, next week is actually my birthday. And on my birthday, we're going to be talking about, let's see. Well, I wish I knew. My list of topics was not here, but you'll find out soon enough. I'll be sure to put that all over YouTube, and for those of you who join us on Facebook. But until next time, landlords, happy leasing.